just so everybody knows sort of where this is headed, we have probably a dozen freestanding bills that we just need to take up and consider. And then we have 3, maybe 4 large issues where we have multiple bills on topic. We have a whole block of bills concerning license, suspension, restriction. That'll be about 2. We have the restitution bills. Those are primarily mine and come out of the Crime Commission. There are 4 or 5 of those. There's a considerable issue involving DUI rewrite. Everybody, as you know, we've taken sort of a light docket one of the Fridays, and we said there'd be a day that we'd have to do a lot of work. This is in fact that day. Okay, so we have in the first block, do we have a sign-up sheet, Mr. Cotter? So I have Delegate O'Quinn, 2429. Delegate, tell us the problem and tell us how your bill fixes it.
All right, thank you, Mr. Chairman. House Bill 2429 adds the same non-resident allowances for mental health restorations that were added to felony restoration by House Bill 1666 in the 2015 session, which the House passed unanimously. So right now in Virginia, residents who've had their rights taken due to any mental health issue can petition the General District Court in the city or county in which they reside to restore their rights. When this was originally addressed in the code, those who lost their rights in Virginia but then moved away had no avenue for petitioning. 2 years ago, we fixed this out-of-state issue for felons who had their rights reinstated, but we've yet to correct it for this particular instance. This allows the petitioner to come to the General District Court for their rights in the city or county that they were last committed in, and I think that's in subsection A of the bill. This certainly, as always, does not guarantee that they get restoration, but it certainly gives them an avenue and really is a sort of a standardization measure so that we treat in-state, out-of-state, and all the various categories the same.
All right, so remember the panel has any questions for the patron?
Mr. Chair.
Ms. Buck.
Yes, Mr. Chairman, there's a substitute that should have been handed out.
Move the substitute.
Second. All in favor, signify by saying aye. Aye.
Aye.
Any member of the panel have any questions for the patron based on the substitute?
What's the difference between a substitute and a... Okay. What is this question?
Any member of the public like to be heard on this measure?
Move to report.
Motion is to make to report. Is there a second? All in favor signify by saying aye.
Aye.
Opposed?
I'm sorry,
I'm sorry?
We're moving really fast. I just got to substitute. I'm just not against it. I just need to just have time. So I'm going to say no just to put it on side time.
All right. No for now.
Should we take it by? Nope. Nope.
No, I need to.
It's all right.
There was
Everything's fine. We work together. It'll be fine. All right. Thank you, Delegate.
Thank you.
Okay. We have Delegate O'Bannon is up next. Is he here? Is Doc here? All right. I have Delegate Anderson. Delegate Bell. They really don't want to get behind the big block, so if you are here for their bills, I would definitely get them. I know.
Mr. Chairman, I want to just bring up the Delegate Bell's matter. That's the same as a bill that I have put in as well. So I don't, but we have not scheduled my bill yet for hearing.
Is it identical?
And you figured it out. Wow.
It is not identical, but it deals with the same code section. But they're similarly compliant with each other. We can take it back for the day.
Mr. Chairman, we take House Bill 1986 by the code.
Okay, so refer to this.
Figured out our...
That'll be the plan. Well, of course, I mean, the motion is properly made. What I'm saying is Delegate Bell signed up. He's not here. I'd like to have him here when we do this, but we don't have a little bit of committee.
Yeah, we should take it back today and we'll explain to him.
Okay, motion has been made to pass the bill by for the day. Is there a second? All in favor signify by saying aye. Aye. Opposed? Okay. And I give you the special subcommittee of one, Delegate Miller. Just when he comes in, make sure you tell him so he doesn't.
I will.
Okay. All right. Delegate Marshall, 2459.
Thank you very much, Mr. Chairman. This measure was suggested to me by Elizabeth Block, who came down here today and was in my district for 20 years, but I was, moved over. But she and I and her husband still maintain contact. This simply provides that a cell phone capable of taking pictures cannot be sold to someone under 18 by a retail establishment. If you do, there's a $100 fine first time, $200 second, $500 for every third and thereafter. This does not prohibit parents from buying cell phones for their teenagers. This simply says if you're under 18, you can't do it. Now, we do many things to restrict individuals under 18. For example, if you're under 18 but over 16 years and 3 months, you need your parents' permission to have a driver's license. You cannot buy a novelty cigarette lighter unless you're 18. If you're under 18, a movie theater may not show a trailer for a movie for which you are not eligible to watch the original and the entire full length according to the guidelines of the movie industry. Surveys in the United States and Britain have shown significant percentages of young teens taking pictures of themselves or other partially or fully unclothed and sexting. Minors who can send out or receive explicit pictures of themselves or others can be charged with the creation of or possession of child pornography and end up on the sex offender registry for life. A Pew Research Center from 2009 found that 17% of minors who pay all of their own cell phone costs participate in sexting, whereas only 3% of minors participate in sexting if the parents buy the phone for them. That's a 560% greater incidence of sending nude pictures of yourself or others than where the parents buy this. Again, 2459 only limits direct sales of cell phones capable of taking pictures to persons under 18. Stores may not sell tobacco products, Playboy magazine, to people under 18. Give you an example. A young teen in a couple years ago named Amanda. She shared a self-photo of herself. She thought she was doing this to someone with whom she was having a romantic relationship. It turned out that this was an adult. This adult kept badgering Amanda for more and more provocative pictures of herself and threatening her with posting the original and other pictures on the internet unless she kept complying. Eventually, Amanda got up enough courage to say no, and she refused to send any more pictures.
Mr. Chairman.
But once that happened,
Sorry.
Delegate Klein.
Just a question, or when are we finished with your presentation?
sure.
Are you close, or are you?
Well, I'm just got a little bit to say.
Okay, go ahead. Sorry.
Eventually, Amanda said no. She was cyberbullied for more than a year, and she committed suicide. I have articles here from peer-reviewed journal magazines where the same thing has happened to other young girls. The incidence of this sexting is significant. This is an article from the Archives of Pediatric and Adolescent Medicine from September 2012. It's a survey of 948 public high school students in Texas. The sample consisted of 26.6% African American, 30.3% white, 31.7% Hispanic, 3.4% Asian. Mixed and other was 8%. 28% of the sample reported having sent a naked picture of themselves through text or email. 31% reported having asked someone for a text or sext. More than half, 57%, had been asked to send a sexual message, picture, with most being bothered by having been asked. Adolescents who engaged in sexting behaviors were more likely to, well, don't have to worry about that. But the point is, this is now a very prevalent behavior. And the evidence from Pew 2009 survey, again, right here, that kids who own their own phone pay their own bills, and these are very cheap. You can get a cell phone at Walmart capable of taking pictures and connecting to the internet for $35 with a 5.1 megapixel camera. All I want you to do is to state, okay, if you're under 18, you can't buy it directly. So, and I have a witness down here who would like to testify at some point, Mr. Chairman.
Is there anybody have any questions for the patron?
Mr. Chairman.
Delegate Klein.
Okay, the ability of minors to contract, I mean, they can try, but most businesses will not contract with a minor. Most businesses will not contract with a minor because they're not enforceable under Virginia law. So most minors can't get cell phone contracts as it is themselves.
This is not a cell phone contract. This is $35. You give the $35, you got the phone, you can take the picture, you can go on the internet. This is not a subscription for several months or 6 months, or you pay by the month. You go in and buy a track phone. And again, I just looked up at Walmart last night, $35, Motorola phone, 5.1 megapixels, $35, you're ready to take pictures, ship them on the internet. Text them to your friend. When I went to Verizon, they sell monthly subscriptions to the adults. I asked them, do you inform the adults that there are controls? They said no. I said, do you inform the adults there are controls? If they asked, they said yes. But that's for a phone for which you are having a subscription over a period of time. Not a phone that you pay right now and buy little installment cards later on as the time runs out.
Anybody else have any questions for the patron?
Mr. Chairman,
Delegate Mullins.
Delegate, would this also apply to iPods? Would that be a wireless communication device?
Hold it.
An iPod?
Okay, I guess it could be. I originally asked for that, but if you can take pictures with it, then yeah, you need to ask, you need to have a parent buy it for you. Now, you can go in and buy 10 of these and pass them out to all your friends who are under 18.
Would it apply to laptops?
I don't think that that's as portable, but if you want to restrict it and buy into some of this,
Oh, it's a wireless communication device insofar as it travels over the wireless internet. Wouldn't that be also as well?
repeat the question, please.
Wouldn't this also ban the sale of laptops?
No, you just have to be over 18 to buy it, or 18 or over. This is not contraband. And the guy that I talked to yesterday from Verizon was really off the mark when he said, I'm forbidding sales. Contraband means possession. This doesn't block a kid under 18 from having possession of one of these things. The parents could do it. When I went into Verizon to ask some questions about this, I was told that parents are buying $650 iPhones for their kids. Well, I couldn't own an iPhone unless I was the delegate. I don't have enough money to buy it.
I have a question for staff. Mr. Cotter, I don't remember when we did all the other things for wireless communication devices. Is that a term of art? Bob, if you know, something we define.
It is used in the texting statute.
Okay, did you ever define it?
No, not, I don't believe.
My camera, literally the digital camera I have, has a wireless downloadable spot. Through Wi-Fi, you can, without touching anything, you can download into the world. This would cover that, I would assume.
It can communicate, but I would suggest it's not a communication device. I can add something, or you could actually buy a Nikon 5300 camera, which can communicate with your cell phone by the program and hardware inside of it. But that's not a communication device, even though it can communicate.
Okay. Anybody else have any questions for the patron? Marshall, you said you have someone here?
Yes.
Okay, so ma'am, please come up. If anybody else would like to comment on this bill, you'll get a chance as soon as she's done. Ma'am, identify yourself and tell us your thoughts on the bill, and you can use the mic. Thank you.
Thank you, Mr. Chairman and members of the committee and Delegate Marshall. My name's Elizabeth Block, and I am from Manassas, Virginia. I'm the mother of 4 children, ages from 22 to 12. I'm speaking to you today in support of House Bill 2459. The reason for my support is because it helps to protect teens from their own impulsivity, and I recently accompanied a married couple through a very difficult time with their teen daughter, and quirks in the law came to light that this House bill helps to solve. Most people do not know that minors as young as 13 can enter a cell phone company retail store and they can buy a phone, and any cell phone they wish, and they can get it activated as long as they prepay for 30 days of service. In this, my experience, we worked through AT&T and we got through a GO plan. It's called a GO plan. Okay, first of all, at least if the parents have phones for their kids and their own plans, they can use parental protections as best they can. However, if minors get their own cell phones and plans, such as the prepaid plans, which are widely available, these are not contract plans. Okay, these protections cannot be used, and the parents do not have access to those accounts. I know this wonderful couple, as I mentioned, who has a daughter with suicidal thoughts and anxiety. They were very reasonable with parental controls on her phone. But at age 16, she got tired of those controls and entered an AT&T store with cash and got her own service, entirely bypassing parental controls that her parents had in place, and the parents were not contacted by AT&T. Now, I'm sorry, but a kid with depressive tendencies is not thinking straight and needs a little more protection. I don't think that any AT&T or cell phone rep knows the children better than the parents. Sadly, within 4 months of getting her own service, Emily was sexually assaulted by an adult who her parents had originally blocked when Emily's phone was under their plan. So now, under Emily's plan, this person was able to contact her. Later on, Emily bought an iPhone on her own and had it activated because her old phone died, still on a prepaid plan, okay, because she's still a minor. She's 17. She can't have a contract, but she can go in and pay in advance. There's no law against that. Emily's parents, now remember, we have a depressed Emily, worked with AT&T to gain access to their daughter's account, this prepaid account. But after months of conversations, chat transcripts, and complaints, all corporate said was to go into the retail store and complain. When they talked to the store, both the manager of the store and the corporate liaison for AT&T said there's nothing they would do. Even if a 13-year-old came in without a parent to buy a phone, they would give them service. Doesn't matter what kind of phone. Both corporate and the retail store said you have to pass a law that prevents them from giving service to a minor. They were not interested in the morality of it, or in their parental rights, or in their ability to protect their children. And I was there for this conversation. I witnessed the whole thing. So the cell phone companies don't know what's going on with your family and your kids. Okay? The parents do. If a kid wants to get ornery and defy their parents, yes, I know that's a family problem, but cell phone companies really shouldn't have that power. Is it not the parent's decision whether a kid has a cell phone, a device that has no boundaries, especially one with internet and photo capability? I'm not going to go on. I know Bob mentioned a lot of statistics. I just want to say a few things. In Bristow recently, a mother looked through her 14-year-old son's phone texts and images and saw the following: go kill yourself. Do it. Go hang yourself. The world will thank you for it. And there was a photo of someone who was hung. Okay? So cyberbullying is a huge problem done through cell phones, and it's highly aggravated by photo transmission. I haven't much time, but obviously 22% of teen girls and teen boys have sent nude or semi-nude pictures of themselves from their cell phones. CNN, do you want me to?
Ma'am,
Okay.
sorry.
Yes.
So I'll just tell the gentleman, we are acutely aware of the problem in that we have tried to solve this in multiple ways over the years and have had trouble finding exactly how to do it. So I don't think you need to convince us that this is a problem. So I think we're going to focus on whether this is a way we can address it. But I just didn't want you to waste your time educating us on something that we have for years have been trying to figure out how to stop kids from doing that sort of thing.
Yeah,
making them felons. You know.
I urge you to support the bill. If I were to change it all, I might add, don't allow the kids to even get service. If they even have an old phone at home and they go into a store, just don't even let the kids get service unless it's on their parents' plan. Thank you.
Thank you, ma'am.
Thank you.
We appreciate it.
All right, any other member of the public like to be heard on this measure? I have some questions for staff. Mr. Cotter, so I'm thinking in my head of things where we have an age limit to buy. I could think of tobacco, alcohol, and guns. Okay. And these have agencies involved. We've got ABC for alcohol. We just made ABC responsible for tobacco. Feds have ATF for guns. Right. Okay. All right. Bills before us. What's our pleasure in the bill?
Move support.
Okay. Motion made for report. There's a second. All right. Motion's been made and seconded to report the bill.
Speaking of the bill.
Yeah.
Thinking about the bill,
All right.
then speaking about the bill.
All right.
So, Mr. Cotter, what, may I ask you that question?
Floor is yours. Go ahead.
We rattled off a few, but what is, do you have a more comprehensive list of things that are age restricted to purchase? Okay, tobacco, guns, alcohol,
Cigarette lighters,
lighters.
Not all lighters. It's the
novelty cigarettes, Playboy magazine.
So question for the patron. My first reaction, admittedly, was this is silly. And then I saw you and I realized, of course, it couldn't be, right? And so,
Good intuition.
yes, sir. She convinced me.
That's why I asked you.
I know. You should just let her lead off and you just hang anyway.
Okay.
But it seems like there are so many things that technology devices. I see what you're focused on the photographic part, but if we're talking about trying to keep kids from accessing the internet, it seems like just things like Xboxes and PlayStations and like everything is on the internet now and everything is internet capable. And I just don't know how we stop them from. Go ahead. You know where I'm
I
getting.
don't know that we can make the entire earth into the New Jerusalem, but if we can cut out a little part and prevent it from becoming a hell for teens who get caught up in this, or parents who now have to deal with this, I think that's some step forward. It doesn't eliminate all the possibilities here, but we have the authority, and therefore I think we have the responsibility to curb it where we can.
And Bob, you haven't heard none of the industry people or have expressed any concern? I noticed we gave them a chance to come up and talk and we didn't hear from anybody.
Well, Verizon, which makes $64 billion a year and has more revenue than we do, the gentleman told me he didn't like it yesterday, but I don't see him here. And if he comes here, I'm going to write everybody in my district and tell them that they think, you
Well,
know,
we already know that.
they should
but
do that. Okay.
Anyway. Okay, thank you, sir.
Mr. Chairman,
Delegate Watts.
I want to go back to Delegate Mullen's concern about the other wireless telecommunications device capable of capturing a photograph or the visual. My problem with that is it's so broad open, and I'm thinking of myself as a parent, that those are larger items that I, as a parent, should be taking responsibility for if such an item appeared. Would you feel that we have made a good carve-out of the New Jerusalem if we just limit it to cellular phones, which are small and inconspicuous and can be kept from the parent?
It's better than what we have right now. I mean, I'm thinking of a device you can buy for less than $60 and put $25 and get about 4 hours opportunity to do this. An iPad, those things cost a little more, but if that's a problem, restrict it to the cell phones, because that's the easiest source of temptation out there to do it, if they could take a picture.
And I also think that it limits the retail places where we will have to look at this.
Correct.
So with that, I would move that we strike after cellular telephone or other wireless telecommunication device that is capable of capturing a photographic or other visual image.
Mr. Chairman,
Did I just go too far?
that might be too far.
Oh, I'm assuming all cellular phones did, I'm sorry, and then you stopped before then. Cellular telephones, just striking or other wireless telecommunication device.
You're right.
I'm sorry, would the gentlelady will repeat the amendment?
Certainly, after cellular telephone, strike or other wireless telecommunications device.
Mr. Chair,
Delegate Gilbert.
so that,
So the amendments are for us, Delegate Gilbert.
so a few years ago, the gentlewoman was here when we figured this out, but we figured out that cellular telephones don't really exist anymore. Like, nothing uses cellular technology, at least nothing anybody's really using. So we added or other wireless telecommunications device to capture the bulk of what people have in their pocket. This is not a cellular telephone. This is a little computer that has an app on it that is a telephone app, etc. So this is not a cellular telephone. And so if you did that, that is pulled from other parts of the code that we've actually had to change, and over the years we've actually found, I had to build it. You can't bring a cellular telephone into a prison or a jail, and we noticed that when we did that change elsewhere, we forgot to add it there, so I had to do a bill to add it there, so you taking it out actually takes us back to the old way of.
Mr. Chairman, if we took out cellular and just said that sells a telephone that is capable of, does that get around what you're bringing up?
Well, I think everywhere else in the code where it says, where we're trying to talk about something like this, just for sake of covering everything possible, the definition is cellular telephone or other wireless telecommunications device. So I'm happy if we one day take out cellular telephone everywhere, if that is actually, if we're done with that term now. But until we do that and we're clear that that is what we need to do, I think this full sentence here is actually what it says everywhere else in the code.
If I may, Mr. Chairman, discussing the amendment, my problem is, as you talked about the evolution of all of this rapidly changing technology, what you're then also seeing is a lot of larger devices that weren't around when we were using the term cellular or other wireless telecommunication device. And so now we've got a whole big element that we didn't have before. I mean this almost seriously, not humorously. Any device that can be concealed carry.
Okay.
Actually, that is the size that we're talking about, is that type of a device.
I mean, you could buy one of those at a Verizon store too, I assume, and be able to communicate over wirelessly with it. I don't know. Anyway.
Mr. Chairman?
I'll recognize myself and then, Mr. Delegate Laws, is there any, more generally, any state in the country that has done this?
I've only been elected in Virginia. I don't know, I just, I mean, maybe you said if you could restrict this to a prepaid plan?
I mean, Delegate Albo, we have what we call the Albo rule.
Okay.
The Albo rule goes as follows. It is easy in your head to identify a problem. It's easy in your head to write a statute against the problem. So in this case, it's the teenager who's mad at mom or dad, gets a burner phone and uses it to commit criminal acts and or self-destructive acts or both. And, no, this is the big one. This is the big one. And the issue, of course, is how much more broader in your net, or how many other people are you catching up in your net to get the one that you brought the bill about. And it is very common in this committee for that to be where a bill, we say, we identify the problem, but getting at the problem has so many incidental impacts. And if no state has done this, I certainly thinking to myself that may be one of the issues. We have the amendment, Delegate Watts, the amendment is before us, but do you want to withdraw it, or what's our current status of the amendment?
I think probably I need to withdraw it.
Okay.
It doesn't take away the concern, and I'd certainly like to see this narrow. Whatever terminology is consistent with.
Mr. Chairman,
Delegate Klein.
I don't know if the amendment's been withdrawn.
Yes.
I think that the process will result in a lot of feedback, a lot of input, a lot of change as it goes forward, I think we will get it more precise. But I think what the patron's trying to do is give parents a little bit of help, and we have been trying to come up with a solution over the past several years. And I think that this might just be an avenue we haven't quite considered yet, but it might be one of the avenues that gives parents that help they need.
Council.
Reading the language of the bill, Judge, I do have an issue with the retail establishment language. I'm not sure how you summons a retail establishment to court, or that you can hold them under a penalty like this, the way this is supposed to be enforced. The other statutes that involve these use person, so you're actually summoning the clerk who sells the phone, not necessarily punishing the Verizon store or the Walmart that someone goes into.
Mr. Chairman,
Delegate Gilbert.
person would also contemplate the company selling it if it's a corporation, right? If you said person, that would mean you could cite the company.
Under the Title or Section 1 of the code, Article 1 of the code, that does mean a corporation under the law. But if an officer is going to write a summons to somebody, you have to summons the person. There's no real mechanism for summonsing a Walmart to court under a Virginia uniform summons, which is what this section contemplates how enforcement is to be done.
Mr. Chair,
Delegate Gilbert.
just strike retail establishment and insert person.
Okay, all in favor signify by saying aye. Aye. Opposed?
Mr. Chairman,
So let me just make sure I understand. It's now been made. So high school kid sells another high school kid this. Okay.
I think we might want to liken this to our ABC statute, where if you are in a bar and the bartender serves you an alcoholic beverage and you're underage, it is not the establishment that's being charged, it's the bartender who's being charged. The same can be said about an individual who goes into an ABC store, buys a bottle of liquor for an underage individual, and then gives it to them outside the store. That individual will be charged, not the ABC store. I think that's.
I mean, the ABC law is always a problem because you routinely have some clerk who sells it, doesn't know anything, makes a mistake, and the clerk is on the hook personally for the class of misdemeanor. We've now made that with this instance. It's going to be the guy at the kiosk in the mall. Personally. What's back to think? One of the ways this is different than all of those is ABC has a huge superstructure of investigators and agents to enforce. Tobacco is now under ABC. But this is asking the Commonwealth to be as law enforcement to be the mechanism, angle, the agency, if you will.
Mr. Chair, Nancy Parr, Commonwealth Attorney for the City of Chesapeake on behalf of the Commonwealth Attorneys Association. Mr. Chair, actually, the association, when this bill came up and we discussed it, our position was that we did not take a position on the bill. So I have to say that I haven't looked at all of the code sections of the definition, but it's my understanding that person included a corporation. If we were going to, if we go after a business, we go after the business and not the individual person. So that was what my thought was, and I can now just say too that for years too the Commonwealth attorneys have worked on trying to get some sort of legislation to, help parents because of what's happening with our teenagers. And after hearing y'all's questions and comments and the speaker today, I do think that this is a step forward. It's more than we've done in the past.
I mean, you're gonna prosecute, it's not,
It's a civil penalty.
no, I know, but, I mean.
You're gonna enforce it though.
You are the
Right.
enforcers, I mean, if this is something that you all wanna use, you'll be able to do, every year you come in and complain about us giving you too much and
I know.
capacity issues, and you don't wanna prosecute DUIs and other misdemeanors because you don't have enough manpower. I mean, this is adding to that list.
I understand, Mr. Chair, that this would be another unfunded mandate, but, so I guess in that position, that we have worked towards trying to get something that can move us forward in these sexting cases involving teenagers and cyberbullying, and that this would be a step that we just have never had before.
Mr. Chair,
Delegate Gilbert.
so how do y'all do, I mean, just curious, how do y'all deal with, I guess on a case-by-case basis, but do you have a general policy? You're not trying to turn 16-year-olds into sex offenders for.
To registered sex offenders for the, no, that is, we try not to.
Right.
We try not to. I'll tell you that we get extreme pressure from parents to do that, but a lot of times that's making the defendant and the victim both registered sex offenders, because there's, the girl is sending the photograph too, and we don't want to do that, and so we try to come up with creative ways through diversion or something to help that. But I mean, it's a serious problem.
So, not speaking for the association, but you at least think this might be a good incremental step forward in trying to at least stop somebody somewhere sometime from being able to do that without their parents knowing about it.
Yes.
Okay, thank you.
Mr. Chairman?
Delegate Mullins.
I've had a case in my career as a prosecutor where we had an adult who provided the cell phone to a minor. And he ended up actually being charged with and convicted of contributing to delinquency of a minor. This statute as written only applies to the sale.
I mean, do we have anything else where we say the sale is illegal, but the item is not contraband, or it's only sales and transfer and only goods? I mean, because those are all we're saying is it's contraband. You are underage and cannot have alcohol. You're underage, you're not allowed to have tobacco. You're underage, you're not allowed to have. And I think that's the trick here, is that we're saying this is something that.
You can have the phone,
And
if your parents give it to you.
Parents can
but
say,
you can't-
right, it's not illegal, it's illegal in Virginia to have tobacco if you're 12, whether your dad gave it to you or not. Right, it's contraband. It's like plutonium or heroin, I mean, something you can't have. And then this is a problem, then an incremental step, which is, it's not a fish for fowl, it's not, I mean, if it's contraband, we could say, weird little special exception for alcohol. We're talking about alcohol in the home. There's a little serve wine at the Thanksgiving dinner exception.
You can do that.
But it's not general exception. But that's what that's your head, right? Did you transfer it? Distribution, you can't distribute. So like porn, you cannot, it's not just can't sell, you also can't give it to
Right.
you. Doug, I'm gonna speak only for myself, I think there's an issue here, as we say, there's an identified problem. This is inconsistent with everything else we do in the entire criminal code, and that's because you're trying to address a very specific thing through a fairly blunt instrument, which is criminal penalty. Criminal penalties is always, it's a sledgehammer, it's bad at being a chisel. I mean, it would be simple to write a statute that said that no minor can possess a telephone.
But I don't
Simple,
want
when I
to.
say easy or right, I'm just saying
Right.
it would be simple to do that. But I don't think that is either what you're asking for
I
or
don't-
what you
no.
want to do. If you say it's not that, so that anybody can transfer, anybody over 18 can buy and then transfer parents, in other words, that's the reason why this is not easy. Speak with Mike.
Mr. Chairman, the issue with this is, you're punishing the kid who sold it. I know we do that with tobacco, and we do that, and mostly it's because we put in that the ABC people should train people not to do this. But if we don't have that training, I think this is just punishing, one kid for selling a phone to his friend, having no idea that, we're not even a friend, but just having to guess whether someone's 18 or not. You're not really getting to the people who are actually causing the problems.
The real circumstance is you can go into any one of these stores right now and buy a prepaid plan. And that's where most of this abuse comes in. I mean, the witness presented the case where the parents were unable to do anything because the daughter had prepaid everything and the AT&T wouldn't assist it.
Mr. Chairman, just trying to understand the process here. So in these AT&T, Verizon stores, you can, in addition to buying subscriptions, you can buy prepaid plans.
A little card with time on it. And it tells you when you've got so many minutes left, correct?
Right, so there's no contract. I will, Mr. Chairman.
Delegate Collins.
So, Delegate Klein brings up a good point. They sell these out of vending machines where there's no control.
All right. All right, we have a couple more meetings. I'm not sure this will get simpler with more thought, but. All right, no, this may be one that we need to think about, but we can't think forever. We've got a couple more meetings here, and what's the pleasure? Okay, substitute motion. All right, bye for the day, which means it's still in the rest of the committee. So there's a motion to go bye for the day. Is there a second? All right. All in favor of going bye for the day, signify by saying aye. Aye. Okay. I don't know where we are. We're sort of pondering this. This is such a very unusual. This is something different. So we'll look at it for a couple days and start putting it back on the docket. Now, we have not Friday because that's a mental health day. We've got Monday and Wednesday. Okay, we'll put it back on the docket. Thank you, Mr. Marshall.
Should I bring my star witness to persuade you again?
She is welcome to, but I think we certainly were. We appreciate you coming. We did all hear. You're welcome to come back, but I don't think you need to.
Whenever we lose faith in him, we're going to remember you being here.
Thank you.
Thank you.
All right, so these were the short, easy bills. I wish I was joking. All right, we have Delegate O'Bannon. Doc, you're up.
Thank you, Mr. Chairman, and I would request that we adopt a substitute which is being handed out for $17.99.
So moved.
To get that, I'm going to request a line amendment on 107, line 107.
Do we adopt the substitute yet?
I moved it.
Move the pending question.
All in favor, signify by saying aye.
Aye.
Opposed? Okay. So, Doc, this is the latest version of it. Kind of.
I'll explain the bill and then we'll do the line amendment.
Yes, go ahead.
So you all are very familiar with the issue of kind of a dowel And we are now in a situation where the FDA has studied this medication, and it is pending FDA approval, and will likely get approved. And so the original bill was just drawn to that. What the substitute does, and I thank the chairman and Mr. Cotter, is probably a better way to go on this, because what this does is basically put into place a process where should this happen again, we won't have to come and piecemeal this. And so basically, 596 addresses the FDA-approved substance publication and how they work with their final rule. And then the very last part of it has to do with how 142, how the Board of Pharmacy will handle this. The line amendment is on 107 after 54.1344.3, comma, add please, or enacted into law. If we should pass a law, that would cover that. So that's basically the bill. And
all those in favor, somebody offer the amendment?
So moved.
Move the second off the amendment. All those in favor of the amendment say aye. Aye. All opposed? Okay. And then basically, yellow again.
The bottom line of this bill is if the FDA approves it, it's not illegal in Virginia during the time that we are adopting it.
on our schedule.
Okay. Any members of the audience want to speak for or against the bill? Any members of the committee have any questions or comments? Is there a motion on the bill? Move a second in the report. Is there a second?
I just pulled out a second.
Okay.
I don't know what this code section is, and I want to make sure somebody's looking at this. Just trying to be diligent here, so. Okay, I'm sorry.
Yes. All right, so we'd simply sort of hit the pause button. All right, Gilbert hits play. The motion before us was to report as amended, substitute as amended. All in favor signify by saying aye. Aye. Opposed. Okay. Where are we doing on quorum? I'm terrified to say that. Well, he's leaving.
Okay.
We're good, okay, all right. Okay, is Delegate Anderson here?
Thank you all very much.
Thank you, John. Rich is about to make a 90-minute mistake if he doesn't, oh, good timing. All right. About to think of everything else. Okay. All right, Delegate Anderson, you have a distracted driving bill, is that right?
Yes, I do, Mr. Chair.
Tell us the nature of the problem, and then tell us what your bill does to fix it.
Well, the nature of the problem is that...
Lopez, you're welcome to stay, but it's going to be a little bit.
The nature of the problem is such that it's reached, not trying to be dramatic here, but it has reached epidemic proportions. I am provided a report every 6 months by the Department of Motor Vehicles because they know I'm interested in this subject. And taken collectively, the sum total for calendar year 2016 is that 175 people died on Virginia highways as a result of distracted driving. Those are the ones they could discern that there was distracted driving. There may well have been more. On top of that, 14,700 during that 12-month period were injured. And again, I would say that that's on the low side because not every instance can you accurately fix that it was in fact distracted driving. Nationally, it has reached epidemic proportions. I've not actually seen the numbers, but I have had several people in the transportation industry tell me in the last week that for the first time in something like several decades, the number of mishaps on the federal highways is now on the increase. And I think a reasonable conclusion would be that that's because of distracted driving. And so that's the problem that we're trying to tackle here. In the end, the measure of merit that I wish to see is for us to take that 175 fatalities and those 14,700 injuries and to start seeing a downward trend in those numbers as a result of common sense legislation for the Commonwealth. So what the bill does is this. Right now, and all of you know this better than I, there are 3 categories of, let's call it, adverse driving practices. There's reckless and aggressive, which can be downgraded to improper. And what we are proposing is a 4th category, which is simply labeled distracted driving, so that it will occupy its own place in the Code of Virginia. Moving down through the changes, what we do is we add in a new section, and it contains these provisions. We specify that it's unlawful for a person to operate a motor vehicle on the highways while using any handheld personal communications device to do these things. 1, manually select multiple icons or enter multiple letters or text in the device. Secondly, to read any information that's displayed on the device or stored within a device, but that does not apply to any name or number stored within a device. Any information displayed through the use of a GPS system, because we wanted to retain that capability for the users when they're using that for the purpose of navigation. And we specified several exceptions. One was the operator of any emergency vehicle while he's engaged in the performance of his official or her official emergency duties. Secondly, an operator who is lawfully parked, and in the transposition of this section from one place in the code to this new place, we did eliminate the word "or stopped," and I would like to see that added back in. Third, the use of factory installed or aftermarket global positioning system equipment that you use for navigation in a vehicle. And then any person using a handheld device to report an emergency. Obviously, there's an overriding necessity for that. So those were the 4 major exceptions that we delineated. We also said further down that a violation is a traffic infraction punishable for a first offense, a fine of $125 for the first offense, and each subsequent offense, $250. That's what it is currently. And that distracted driving would be included in driver's education training. And then the rest of the bill goes into defining what exactly emergency vehicle is, to expand on the provisions previously in the code. So that, in a nutshell, is what the bill does, and there are folks here who wish to speak to the bill, Mr. Chairman.
Okay. Anybody have questions for Patron?
I have a question, Mr. Chairman.
Delegate heard Adams first and Alba.
Okay, well, Delegate Anderson, I was just curious about how this is different from the legislation that was proposed last year. I think that went to transportation. Last year, as I recall, there was amendments to the existing statute prohibiting certain texting while driving, correct? Was there a particular commission it was referred to, or additional work that was done by another group that led to this?
Mr. Chairman, the additional work that was done in the interim was that this bill, when heard last year by the House Committee on Transportation, was referred to the Commission on Transportation Accountability. That's what it was called. And from there, they put together a stakeholder working group. A lot of the stakeholders are in the room today. The principal presence was obviously Drive Smart Virginia. And this is, through our work, the final product that we came up with. And again, you see that we have delineated a new section in the code specifically devoted to distracted driving. As I'm told, and I need to really let law enforcement speak to this rather than me, but there were sentiments expressed as we moved through this that law enforcement is very hesitant to write an aggressive or reckless ticket, and this gives them a particular niche to where they can direct the citation right.
Look at that,
So the threshold question is whether, I think that this behavior is already recognised, and we've had this discussion many times. So the threshold question is whether we want to make texting and drop the punishment in order to encourage police to write it more. Isn't that kind of the first thing we gotta decide?
We have a texting law, we have a reckless driving law. This would be a more expansive version of the texting law. It's not a general distracted driving law, to use the terms we've used over the years. It doesn't talk about eating, it doesn't talk about fussing at the kids or something. This is tied to device use. It also doesn't affect, as far as I can read it, telephoning. Doesn't have that conversation about hands-free or some other issues. We're at the wordsmithing stage yet, but I'm trying to see. So last night I needed to go to a restaurant that I didn't know where it was. Because I was running late. It says it doesn't refer to a GPS and it doesn't refer to the information already in the phone. But when I call up the restaurant, it was neither of those. So I said Spoon Bread Cafe, what it was called. And then neither of those are what then got me the information for Spoon Bread Cafe. And then I said, whatever the directions, there's Google pulls it down. And then from there on, I'm using the GPS device, but the first step would have been illegal. Is that right? I assume it would be under the way it's written here. Because I was reading information. I didn't type anything. I used the voice recognition, but I read information displayed on the device that was not there before, nor from
Chairman,
GPS.
is part of the GPS function or the calling function?
Well, neither. I mean, once they have the address, then GPS takes over, and I think I'm safe under that section for the directions. I'm saying the first step where I say, find Spoon Bread Cafe, and Siri or whoever it is says, here it is, at such and such address. And then I hit the directions button, and then it all takes over and says, go left, go right, go left, go right. I don't see why that first step would not be illegal. How does this relate to what other states have done? Does one know? I hate to reinvent the wheel here. This is a heavy lift.
Well, several states, I think as part of the process, some of that data was collected from the National Conference of State Legislatures. Around us, we have a hands-free bill in the District of Columbia and in Maryland.
I just think on this, in this wheelhouse, the texting part. I'm not talking about telephoning or hands-free, but I mean this. We have a texting law. Other states have texting laws. Has something that we shouldn't have to be the first state that kind of parses through this.
Correct. Correct.
Yes, ma'am.
Why don't you come over here? Mr. Chairman, this is Janet Brooking of Dry Smart, Virginia.
Hi.
So there are 48 states that have all-out texting bans right now, and there are about 16 states that have more of a hybrid law like this, and they're all written very differently.
Okay, well, the issues I'm sure are true around the whole country, which would be people now use their phones for much more than playing with the new game, Candy something. Anyway, okay. Kids these days. But they use it for obviously navigating. So when we first started this conversation, like 3 or 4 years ago, the big issue was Garmin GPS. That's passe. But how do they get around this issue that if you want to have, I can't believe they don't allow GPS. Maybe you tell me they do, but I believe it. It wouldn't even be.
There's no law that's been written as a model law, so each state addresses it differently, but I believe most of them do exempt the GPS.
Okay, and then how do they address the issue I just raised, which is the information you need to make the GPS go?
I'm going to let
Nobody wants me to watch.
answer that.
People don't want me to watch the UVA game. They do want to say we want to let you get at the address for the cafe.
Get directions.
Well, right, but that's not.
Dana Schreiber, Police Chief. I probably should defer to my resident expert here, Chief DeBoer from Herndon, but I would guess that really to be in complete compliance with a law like this, if you need to find that address for that restaurant, you would do that in a park position. You would put it then into GPS mode, and then you would drive, rather than trying to do that while you're driving.
Okay. I mean, the only carve out for GPS is you've already got the address in the system and you say, direct me.
Mr. Chairman, which is what we all have to do in a later model car anyway, because as long as the speedometer reads anything other than 0, those functions are disabled. So it would mimic those kinds of behaviors that exist with the onboard installed GPS.
Delegate Alba Gilbert.
How about a process thing? Okay, so we got a Minshew bill, which basically keeps the behavior of texting in a reckless. We've got an approach Delegate Anderson wants to use, which is creating a new kind of traffic offense for texting. And then we have the idea that you would not do anything in code and just require hands-free. If we are going to...
Hands-free is a whole different idea. That's the telephoning part. This is the, if you will, like, texting issue.
Yeah. But you couldn't touch your phone anyways, right? So we could sit 2 hours here and try to work on this concept, and then at the very end decide we want to keep it reckless. So it seems to me that it might be smarter for us to decide what approach we want to use. And if we want to use that Delegate Anderson's approach, then we keep working on it. If we want to use the reckless is still texting is still reckless, and do the concept that we've been discussing up here, then we would throw out an idea for a draft and send it off for another day.
We can maybe mess it up, Mr. Chair.
All right. I hear the chair. I'm open to that. Delegate Gilbert.
Before we decide that, I want to take off. So the chief or the Commonwealth attorneys or anybody in law enforcement, can anybody tell me what the problem is where if a state trooper or a Herndon police officer pulls up next to somebody who's driving down the road and they're just doing this while the car is moving that way, why can't they successfully be convicted of reckless driving in any court in Virginia? Is it the judges? Is it the police don't understand? And isn't there some other way we can educate people that doing this is as dangerous as being drunk and driving down the road? Like what I was one that said the original reckless driving was just fine to handle this, or should be.
Thank you for asking, Chief Maggie DeWort from Herndon. The problem with the code, it's not necessarily where it's parked or what the penalty is. It's how to enforce it. And an officer can't differentiate when you're driving down the road, whether you're actually texting or reading.
I understand that. Here's my question. The reckless driving statute says drive in any manner as to endanger life, limb, or property of another.
Correct.
So if any competent police officer could articulate in a court of law under oath, Judge, I saw this person driving 65 miles an hour, they had their head down, they were looking solely at this device, and they had both thumbs on the thing and not on the wheel, and clearly they didn't see what was going on in front of them, and any judge should be able to say that that is clearly a danger to the lives of others. That's my question. So the problem is we've now said you have to differentiate between are they playing Tetris or are they texting, and I don't care about that. I'm saying reckless driving, 852 generally, why can't that be used to enforce this kind of behavior?
It's still very difficult to articulate. Maybe going 75, 80 on a roadway and doing that, or 20 over. In some jurisdictions like mine where the speed limits are much lower, that's a very difficult argument to articulate. So really being able to articulate to a judge and getting that through, and it's not that there's opposition there, but trying to define or articulate reckless when you may have somebody's head down, but you don't have a driving behavior with it at the time, doesn't mean that 5 seconds down the road they're not going to rear end somebody because they're not paying attention or they don't see the light. So what's different between the texting, in my opinion, and DWI or any of those others, you have a driving behavior that you are actually stopping that car from. The mere fact that they're texting doesn't mean that you may not see an associated driving behavior with it, and that's what the judges are generally looking for. They're looking for what behavior, other than the fact that they had their head on that phone or their fingers were going, made you think that that car was being operated in a reckless manner. And it's very difficult for an officer to articulate that without really egregious driving behavior to associate with that.
So you just told me it's a judge problem, that judges don't think that you not looking at where your car is headed.
I don't know if it's a judge problem, but they're expecting us to be able to give something other than the fact that their fingers are on the phone or their head is in the phone. And we oftentimes don't have that driving behavior until something's too late. The problem is epidemic. It's growing. Just in my jurisdiction alone, the accidents have increased over the last 5 years I've been there just tremendously. So we have nothing else to point to other than the fact that a large number of our accidents are rear-end accidents.
and they're admitting to that, or I didn't see him, they're very much distracted, whether it's the phone or other technology. There's definitely a correlation between the two.
So just remembering back, so in 2013 and 2014, we worked on and/or made amendments to the texting statute, which is not this, nor did this amend this, right?
What I believe we did in 2013, Mr. Chairman, was we elevated texting while driving from a secondary to a primary offense and increased the penalties to 125 and 250 respectively.
Okay. And that's the 462-341:20, 20:5. This, you and I talked before, you could have a distracted driving statute that has nothing to do with devices. And it would, as we always say, cover the dropping the pizza in the front seat of your lap and fussing at your kid in the back seat and changing the music and all the things that people do that are in fact distracting. Because this is tied to devices, we would want to make sure we keep it consistent with the existing texting statute. We shouldn't have two completely different. How is this different? What does this do so differently than that? Okay, so this would be in lieu of it. That's the question again. I mean, we should not have to, Rich, or council, we always seem to be churning in the same quicksand of this. Surely, if we've got every state in the country, including big and small, smart and dumb, working on this very issue, how have they addressed what phone functions are those we're trying to address? How do we get the ones we need but not the other ones? What do they do?
Mr. Chairman, I did a review of them, a lot of states. I did pull out the New York law because I thought that was the closest one to what this did. In the New York law, it's a hands-free, but if you take out that part of it and just talk about the texting, what it says is composing, sending, reading, accessing, browsing, transmitting, saving, or retrieving data such as email, text message, or web pages, viewing, taking, transmitting images, or playing games. So it actually puts out each sort of behavior. It does exempt GPS. It exempts if the device is attached to the dash of the vehicle, and there were the usual emergency operator and using it in an emergency exemptions. But that one was the closest one. A lot of those ones that do pull out behavior tend to get very specific about what behavior that you cannot do on your phone. And then you have the completely hands-free, you can't touch your phone statutes.
Okay. Rich, the existing statute, I presume you are saying is not sufficient. Well, we have it. We passed it a couple of years ago with even more thought than this, and went through, as I recall, 2 or 3 committees. What's happening with that law? I don't know. Council,
Mr. Chairman, one thing I can tell you is that law doesn't, you have to actually be sending or retrieving, so it wouldn't, you were, as Delegate Lupasi says sometimes at the CLEs he teaches, that you can read War and Peace on your phone.
I understand that. I mean, so that's something that's not covered.
That's not covered by the existing statute.
Mr. Chairman, as part of the development of this legislation and this public policy, we right now have something that's kind of like Swiss cheese. It covers some things, it doesn't cover other things, and frankly, they all look the same to a law enforcement officer, and they really are the same kind of manipulations on the phone, but we've created a statute that has some things that are allowed, some things are not allowed, and for law enforcement, that makes it almost impossible to enforce without actually getting a subpoena to get the cell phone and pull the records, and that's not feasible.
How many times, do we have a conviction rate? How many times was it used in the last year to prosecute and convict people?
John, I don't know if we know that. I mean, to be honest with you, right now, on a practical level, we use this statute obviously for education for young drivers, and frankly, it ends up being used.
Well, then, I mean, somebody's using it. I mean,
in crash investigations. I don't know if anyone from DMV can answer that question. Commissioner Holcomb says no.
I mean, my memory was the last time I saw it, it was about 750, and that's an ancient history, probably wrong. Can anybody tell us, in other words, we're saying it's a completely unworkable statute, And we have some people that are telling us they don't use it, which I believe you. I'm just, if it's being used, do you know, do you recall?
I don't know, Eileen Smith with the
Yes.
port, but
Thank you.
if it's a specific statute, I think we should be able to pull a number.
It is, I mean,
It's
it's,
charged, I just don't know the specifics, but we can pull data based on a charge.
right, I mean, it's 46.2-341:20.20:5. It's the texting statute.
46.2-341.
.20.
It's, I'm sorry, 46.2.10.70.
Say it one more time for.
Sorry.
40, Mr. Chairman, it's 46.2.1078.1.
1078. And that's something if you want to carry it.
I mean,
Certainly we can try and
The
get.
reason I'm saying that is there are statutes that are so fundamentally broken, we start from scratch. Because when we write a bunch of new text, we make a zillion mistakes, and we spend the next 2 or 3 years cleaning them up. Yes, ma'am. Yes, ma'am. There are other ones that are you bring yours. Yes.
Mr. Chairman, just to mention while she's looking that up, one of the things that the officers typically are resorting to now is using the code section for fail to pay full-time inattention, which really they can use in lieu of that, because they don't have to prove specifically that they were texting, so they're, it would be
Good, I
interesting.
tried to look out, we call it, I don't know if that's.
Yeah, and it's, you still need a behavior associated with that to show the courts that yes, they were not paying full-time attention, but that does